There has to be some common sense.
Yes, sir. They have the car stopped in 10th and Ranch by Kohberger.
We still don't know who pulled the trigger. Hello, everyone, and welcome to Police Off the Cuff, Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, a 27-year veteran of the NYPD, and I got some good guests tonight. We're actually, we're a little bit surprised. I don't know if we should say surprised, but of the grand jury indictment of Bryan Kohberger that was breaking news yesterday. Actually, someone broke it during the night, but that's neither here nor there. Grand jury, they're deployed in secrecy, and that's the important thing. So that the prosecutor, Bill Thompson of Latah County, he was working behind the scenes and clandestinely, or if you want to use that word, presenting evidence to the grand jury in secret, because grand jury proceedings, no matter where they are in this country, they are secret. But one of the good things, if you follow the criminal justice field, if you follow the courts, if you follow Supreme Courts and trials, is that it's strategical. And what do I mean by that, strategical? The district attorney of Latah County, this was a strategic move. I don't think he really liked the idea that the defense was starting to subpoena his witnesses, that he didn't necessarily want interviewed or want, their testimony out in public prior to what seems almost a sure thing that this case is going to trial. So, as is his right under the criminal procedure law, he impaneled a grand jury to hear this case. And strategically, what that does is now the defense is not, they don't get the automatic right to interview witnesses because they were the witnesses in the grand jury. And now there's an indictment known as a true bill. And that precludes now the defense from interviewing these witnesses, of course, who we know, Dylan Mortensen and Bethany Funk. They wanted to interview Bethany Funk. And you know something? These witnesses are probably a bit reluctant since they were in the house where 4 students were brutally murdered. And they're being put on the spotlight. Their testimony is going to be extremely, extremely important. And by impaneling this grand jury and presenting not all the evidence, but enough evidence to get an indictment, and it's not a unanimous vote, but enough to get an indictment, the case will proceed. And will proceed quicker than it would have, because right now, scheduled for Monday morning at 0900 hours in Latah County is the arraignment of Bryan Kohberger. That wasn't supposed to happen until the hearings on June 26th. And that wasn't even going to be an arraignment. That was going to be a probable cause hearing. Now, because there's a true bill as issued by the grand jury, he is going to be present, of course, and he's going to be required to make a plea. Guilty or not guilty? I mean, I can't imagine he would plead guilty, but the not guilty plea will result in a judge setting forth a date for trial. And that date will be contingent on a lot of things. The judge's calendar, the defense's calendar, the prosecution's calendar. I can't imagine the district attorney of Latah County has any other cases on his calendar that are more important than this. So that date that the judge is going to set forth for this trial is, as I said, contingent on a lot of things. And one of the things that we predicted as being experienced law enforcement officers is that all parties involved will probably put this case off till at least September or October. I don't see them working through the summer. And by working, I mean, see them being prepared to go to trial in the summer, even though the defense has had 6 months to work on this case, to come up, to question the discovery. And have they received all of the evidence as required in discovery? Undoubtedly not. So there was enough evidence presented to the grand jury that they received a true bill or an indictment in this case. With me tonight, I have two very special co-hosts with me. And the first one I have is Professor Michael Geary, a criminal justice professional, also a retired NYPD sergeant, and he happens to be a lawyer. Welcome to the show, Mike Geary. How are you tonight, Mike?
Hey, Billy. Good. Thank you for having me.
It's a great thing to have you because my lawyer knowledge goes only so far, since I don't have a law degree, but some knowledge of the law. Anyway, also with us tonight is retired NYPD detective and straight out of Brooklyn, Phil Grimaldi. Welcome to the show tonight, Phil.
Thank you, Billy, and thank you for having me. And how you doing, Mike?
Good, Bill. Good, Phil. Good to see you.
Same here.
So, Mike, let's go to you first. I mean, was there anything that I said in my opening monologue? I'm getting to be like a late night talk show host here. Was there anything I said in my opening monologue that was in the least inaccurate from your knowledge and experience as an attorney?
No, not at all. Originally the district attorney in Ladder County was thinking there was going to be a probable cause hearing in June, the end of June. He had 6 months to prepare for it. But I think what happened was the timetable was changed simply because of the defense attorney's request to get Bethany Funk, and not sure about Dylan Mortensen, but definitely Bethany Funk, on the stand and grill that poor young lady who survived that massacre. And he wanted to do that in order to discredit her. And also, he wanted to be able to cross-examine at that probable cause hearing any and all of the witnesses that were presented by the district attorney. So it would give the defense a lot of ammunition because they could sit there and gauge the strength of each witness that was presented to the judge. They'd be able to cross-examine them, see their weaknesses, and then figure out some trial tactics that they would employ, a couple of months from now when we get to trial. And I think that what the district attorney did was fabulous. You just basically block the defense attorney from doing that. This is, we talked about this before. It's kind of like a chess move. I'll make a move. You make a move, I make a move. I'll try to block your path of moving one place, and I'll try to get you into a trap where you can't move. I'll block you from doing something. That's what this is. This is the gamesmanship that goes on between defense attorneys and prosecutors. And so it's part and parcel of the criminal justice system at this point.
Mike, it appeared before it came out that they, in fact, took this case to a grand jury and they, in fact, got a true bill or an indictment. At what point do you think that that Bill Thompson, the Latah County DA, called the defense and said, listen, we got an indictment? Would he have had to notify them while the grand jury was in session in case they wanted to? They can't cross-examine witnesses,
No.
Right?
No, in like New York, and I'm sure it's the same thing as Utah, there's no defense attorney allowed into the grand jury room when they're questioning witnesses. And so it's just the prosecutor questioning witnesses. And the prosecutor's directly examining all the witnesses that they think they need. They're not going to bring in every single witness that they have, just enough witnesses to prove probable cause. Is it more likely than not that the defendant, Mr. Kohberger, is the one who committed these homicides? They're not asking the jurors in the grand jury to determine ultimate guilt or innocence beyond a reasonable doubt. You're just asking them to decide whether or not there is merit to the case. Is it more likely than not the police got the right person and we're going to move forward to trial? And so I think that he probably proceeded in secret, did not tell the defense attorney at all, he has no obligation to tell the district attorney that, at this point that we're going to be in a session with our grand jury, tomorrow morning at 9 o'clock. No, he only has to notify the jury after the indictment has been handed down, a true bill, and then schedule what we're going to see on Monday, which is the arraignment on the indictment. So it's secretive, and the defense is not part of that process, that grand jury process.
Mike, before I go to Phil, and I know Phil's dying to jump in, I want to ask one question. Now, and this really wouldn't apply in this case, but if a defendant wanted to testify in a grand jury, then the defense attorney is allowed into the grand jury room. Isn't that correct?
In New York, I don't think a defense attorney is allowed in the grand jury room. They go in there basically unarmed. Now, I don't know if it's the same in Utah. Each state has the right to change it a little bit.
Mike, you mean Idaho?
I'm sorry. Yeah, Idaho.
I was wondering why you moved the case to Utah.
Yeah, Utah. No.
It's better skiing, I guess, but Idaho.
Yeah, in Utah. Yeah. So the only time a defense attorney probably, and if I'm thinking as a defense attorney, that I would allow my defendant, my client, to go into the grand jury room and face the prosecutor in front of the jurors without my presence would be if it was some sort of maybe self-defense case, a homeowner used deadly physical force against a person or something like that, where you're looking to make your case, you're looking to allow your client to make the case to the grand jurors to say, look, I've got some sort of my own affirmative defense, which is in that case would be self-defense. But no, I don't think any defense attorney would allow their client or would advise their client, go ahead into that grand jury without me being there in any other case other than some extraordinary case like a self-defense case, especially not in this case. Absolutely not.
Phil, I wanted to ask you, and I know you followed this case right from the beginning, and a big problem with this case, again, a judge issued a gag order. However, there's been lots of leaks. Someone is a mole inside this investigation that is leaking information. How do you think this grand jury, the secret nature of a grand jury, how was this not leaked? Perhaps the mole may have lost his, lost the nerve. I'll use that word. Lost the nerve to leak secret grand jury information to the press because it's been happening with everything else.
Apparently, everything with the grand jury was run very tight because we didn't hear anything about it. There was not even rumor, innuendo, nothing really leaked out about it. But I just want to echo what Mike was saying about sort of like a chess game. He used an analogy of a chess game, and I think he's quite right because, as we know, BF was asked to come to another state to testify or to be deposed, and there was a little bit of back and forth, and they decided to go where she was to be deposed. So I think that's when they must have impaneled the grand jury to preclude that from happening. It was almost like an intimidation attempt. The defense is trying to maybe do a little bit of intimidation. Perhaps there was something in a statement that she made to the investigators in the early part of this investigation. They made a statement publicly that they believed that there was something in there that might exonerate Kohberger. So again, I agree with Mike on that. It was probably a chess move, something done to preclude her having to go testify 2 times or be deposed 2 times. Let's say once, in that preliminary hearing regarding the evidence, and then again after an indictment. So he's going to be indicted. I read today on the internet that his blood was a match for the blood that was found on a night sheet. I think we all kind of knew that since his father's blood, his father's DNA was the match that they started out with. So we believe, and it's being reported that it's his blood on the knife sheet. So again, Mike, I think you laid it out pretty good. When you go to the grand jury, you put limited amount of witnesses, perhaps some investigators, police officers, limited testimony. You want to just make a structure. You want to make a basis for the case moving forward. At the end of it, the grand jury decides to vote. Yes, there's enough evidence here. We do believe that there is enough to move forward with this case. or they vote no true bill, that we don't think there's anything here regarding this defendant. The true bill was obviously met. The standard was met. So we're going to have an indictment on Monday, a proceeding, and we're going to move forward from there. I'm just dying to see. I'm sure everyone that followed this case is dying to see what other evidence there is. We have the list of the things that were taken out from the crime scenes. The results of those examinations is really what's on everybody's mind. We do know about the DNA as of now on the sheet.
All right, Phil, I just want to go. I want to stay with this, with the grand jury thing for now. As a strategic thing, I think this was a brilliant move by Bill Thompson. And don't forget, he has 2 deputy attorney generals assisting him, since this is a death penalty case. And if Bryan Kohberger is found guilty after trial, he is eligible to receive the death penalty. And Mike, I want to also ask you, in regards to the charges, 4 counts of first-degree murder and 1 count of burglary first degree. Is the burglary first degree a necessary charge in order to raise the murder charge to a murder first degree, like in the commission of another felony, which is the burglary? Is that Idaho law?
Well, I usually, when you get like a burglary case and there's a homicide that takes place, they may often charge a defendant, a criminal suspect, with felony murder. You may have a case where, like for instance, someone burglarizes a home and they struggle with the homeowner. The homeowner passes away. They've caused that death, and we have in New York State and many other states, you have that felony murder law, which says that, in the commission of a felony, you ended up committing a murder. And that's not a capital case, usually all by itself, because the original intent was to commit the burglary. And unfortunately, the homicide was incidental to that. But the theory is that the defendant did not go into that crime looking to kill. And the killing was, unfortunately, an incident of the original felony. So it would be a felony murder.
But Mike, I don't wish to stump the professor, but in Idaho, is it necessary in the commission of a felony to commit murder? Is that a necessary element for there to be a murder first degree?
No,
Okay.
Because
that was my question.
Okay,
you went on and on like an attorney.
I'm sorry. I clicked
into the attorney version.
I'm sorry. I just click into it. Because there's multiple murders, and so it's like mass murder kind of thing. If you in many states that have death penalty laws, if you kill more than one person during a murder spree, that automatically, the fact that there's more than one would make you eligible for, that's what's called an aggravating factor. And so in Utah, it'd be an aggravating factor if you killed more than one person. So, but you don't need the original burglary in order to have the death penalty case, because those murders could have occurred out on the street. They could have occurred in a bank, say during a foiled bank robbery.
So Mike, my question is then why did they charge the burglary? It's a much lesser charge. Why did they charge it?
I think just to establish kind of like the timeline and his intent to go in there with a knife and to kill. He didn't take anything out, like cash, jewelry, silverware, gold, a seat, a video, a television set over his shoulder, nothing like that. I think they did it just to show that he actually entered the house with the intent to kill. And
so again, it was strategic. It was strategic.
Yeah,
they wanted of course, they're looking at this as going to trial.
Yeah.
And why the hell was he going into this house?
Right.
Burglary. And he went in there to kill people. But, I was always thinking that they would add the lesser charge in case he beat the other charges.
That too, because you never know what a jury might do. You never know. But I'll give the 10-second answer is no, the burglary isn't absolutely required for the capital murder case.
Don't send me a bill for $750 either.
Billy, can I just make a quick comment about the burglary?
Go ahead.
because
Absolutely.
someone asked me today, it's being reported on the internet that he's being charged with robbery. They mean burglary. The burglary is, if you read the statute, now this is first-degree burglary because a murder was committed during the burglary. You enter or remain unlawfully with the intent to commit a crime. Now, he entered into the house with the intention of committing the murders. That's where the burglary charge comes into place. And I think it was quite proper to charge both. 4 counts of first-degree murder and 4 counts of burglary first degree. Whether or not he took anything, that is, there's talk on the internet that he may have taken one of the person's identification. We don't know if he took a souvenir. If he did remove any property at all, again, that would sustain the burglary charge. But the burglary charge is based on, from my understanding and what I'm looking at, the fact that he entered into that house to kill those people. That's the answer to why he's being charged. Because people were asking me, well, was it a burglary gone bad? And no, it was he went in there to kill, but the burglary charge fits the statute because he entered or remained unlawfully with the intent to commit a crime.
All right, let's see what Dan Abrams has to say. He's one of my favorite folks on this channel.
A major new development tonight in the case against Bryan Kohberger, the man accused of the murders of 4 University of Idaho students last year. There will now be no preliminary hearing in June, as had been scheduled. He has now been indicted by a grand jury in Leta County, Idaho. The case now goes straight to court in Moscow, Idaho. This is a big advantage for prosecutors and can only be seen as a setback for the defense, who wanted to question and cross-examine witnesses. In December, Kohberger was arrested in connection with the deaths of 20-year-old Ethan Chapin, 21-year-old Madison Mogen, 21-year-old Kaylee Gonsalves, and 20-year-old Xana Kernodle. Kohberger remains in prison without bond. Today's indictment means the 28-year-old will not have a chance to challenge the evidence at a preliminary hearing. It also means the 2 surviving housemates who did not want to testify at this point will not have to testify. And prosecutors get to keep more of their evidence under wraps until the trial.
I think well explained by Dan Abrams. And so you can see strategically, especially you folks listening to this podcast, strategically, it made a lot of sense that the prosecutor went for this grand jury, which is always secretive. The grand jury proceedings are secretive. I see some of the media go, this was a secret grand jury. They all are, you know. So you're not breaking any new ground there.
Last month, the judge rejected a request for surviving roommate Bethany Funk to have to be in attendance for the suspect's preliminary hearing, but an agreement was reached where she would meet with Kohberger's attorneys in her home state of Nevada. A new arraignment has now been scheduled for Monday. Kohberger is going to appear before a judge, enter pleas to the 5 charges. Joining me now, Jesse Weber.
I want to just discuss something, and I've seen defense attorneys use this as a strategy too. Exhaust a witness before a trial even happens, so that the witness loses their, I shouldn't say ability, but loses their tenacity, loses their desire to be a witness. And we would see that as unscrupulous and, a lack of integrity, but, they're not called lawyers for no reason, and Mike didn't like that. Anyway, but I've seen that happen. Could that have been partially what the defense was trying to do with Bethany Funk in this case, Mike?
Yeah, I think so, because in a trial, when the judge wants to move the trial along and doesn't want extraneous questions being asked that are really irrelevant and just there for tactical purposes, and because they've got a whole bunch of witnesses to go through, the jury's there, time is money, you got to get this stuff done. In some sort of testimony in Nevada, the defense attorney could go at Bethany Funk for hours and ask all kinds of questions and really just scare her, try to get her upset, try to get her to say a few inconsistent things. It's on the record, it's sworn. If that happens, then 6 months from now or 4 months from now, when we're at trial and she is on the stand, actually during the trial, the defense attorney could use any statements that were inconsistent against her and beat her up again right in front of the jury. So yes, absolutely. The defense is going to zealously advocate for their client. And if it means, hurting some people, then they'll do it. They'll do it.
Phil, when I said that sometimes the defense will beat up a witness to make them sort of lose their zeal to testify, I saw you nodding your head. You've worked numerous homicides, and I've seen this happen too. And where the one witness, say in a murder, that was reluctant to begin with, gets beaten up by the defense pre-trial, and then this person was, I don't even want to testify anymore. I'm done. I'm not testifying. You've seen that, right?
Absolutely. And I think what's unusual in this case is that in New York, the defense attorneys would not be able to get to depose a witness on a case until they were in the witness stand at the trial. Now, you would do trial prep and prepare the witness, but now this was like they were going to get two shots at the witnesses. So I think, and they also have to make an application to the judge to say, we want to depose this witness. We found something in the witness testimony we think could be exculpatory, which means that something that would exonerate Bryan Kohberger. So now they're going to bring it to the judge and say, this statement is what we want to question. And the judge will allow 4 hours, 8 hours, 16 hours, whatever it is, the amount of time that the judge sees fit for that deposition to take place. Now, Mike is 100% right. In a deposition, they can ask you things about anything that went on in your life, or anything that's going on in your life at the time frame that we're talking about. So they have a wide range. They have a lot of latitude of the questions that they can ask. But I believe that there's something in this statement that she made to police that they specifically went out of their way. And again, they want to rattle her. Perhaps that could make her back off. She could be accused of lying in that deposition. Now she might become defensive. I'm not lying, And again, it's it's sort of a mind game, and it's a defensive game. Like Mike said early on, it's like almost like a chess game. So it's one of the strategies they're going to use, and that's what I believe that was about. Great point, though, by the prosecutor to go ahead and panel the grand jury, get him indicted, and now all bets are off.
Mike, a good supporter of Police Off the Cuff, a friend of the show, Lou Lamoracco.
Oh, yeah.
Mike, let's not forget the digital evidence coincides with felony burglary. 12 times on Wi-Fi network. It establishes behavioral patterns, which Chief Fry hinted at early on. Please comment if possible.
Yeah, I think, thank you very much, Lou, for that. That's really good. Yeah, the amount of electronic evidence is extensive, and they went back, I am sure, from like July. I'm sure they went back from July all the way to November 13th. And establishing a pattern of conduct allows the prosecutor to infer criminal intent. And as we say occasionally, a consciousness of guilt. A defense attorney could say, anything they want. They can always make up an excuse. But all of that electronic evidence, anytime he appeared to have gone around that area, I'm sure they have a lot more video evidence that we even know about from cameras in the area that all establishes criminal intent. And the longer the criminal intent takes place over the course of like chronology, minutes, months compared to minutes, weeks compared to days, when you could show that criminal intent over a period of time, it makes it more convincing that yes, this was absolutely a planned, cold-blooded murder, not a burglary gone awry.
That's for sure.
Definitely.
And that's what, I really like this strategy by the Latah County prosecutor, Bill Thompson. And, Phil and I, when I spoke about this witness, Bethany Funk, getting beaten up by the defense, that's a real thing.
Yeah.
And she could lose, they could so beat her up in a hearing that, and I don't want to beat this to death, but that she would lose her tenacity or her impetus to testify and really be terrified to testify. Because look, if that happened in a hearing with just attorneys, what's it going to be like when I'm sitting in that witness stand with a jury in the box, the defendant, who they're of course terrified of, sitting in the courtroom, in a packed courtroom? What will that be like to testify, Phil?
Well, it's very, very traumatic. It's almost as if the person now has to relive it. Now, these kids went through a tremendous trauma. They were in a location where 4 people were slaughtered. They were not hurt or harmed by the intruder. However, it's super, super traumatic to think about it. And again, now you go on the stand, you're going to be called out, maybe even, pointed out specific things that you said in your statement, inconsistencies. They're going to basically try and tear down that witness, call that person a liar. And again, I think, Billy, you're hitting the nail right on the head. It might perhaps cause that person to maybe change something they said previously. Now you have an inconsistency in statements. And again, that's something that the defense team can hang their hat on in summation at a trial to try and create doubt in the case.
Look, we as all being New York City cops, we all testified at trials, whether they were homicide trials, robbery trials. And usually the trial didn't occur till at least a year to a year and a half after the incident. So you don't always remember things exactly the same. And of course, that's where good notes come into play. That's where the professionalism of a good police officer, detective, sergeant comes into play. And you take your job very seriously. You have good notes, because there's nothing wrong when you're on the stand, when someone's peppering with you with very explicit questions and wants definitive answers. And you just say, counselor, could I refer to my notes? They, of course, as soon as they hear that, they're like, oh, shit, this guy's done this before,
Right.
Because if you try to do it on memory, you're going to fail. So, because no one can remember exact specifics from something that occurred a year to a year and a half prior. But if you say it differently, as we know, the defense will say, that's not what you said in your grand jury testimony. That's not what you said in this hearing. That's not what you said in this paperwork. So you can be made to look like a fool.
And they'll also point out, well, you said this in the grand jury. So are you lying today or were you lying then? And then they're putting words in your mouth. Obviously, a prosecutor would object to something like that, but they're still planting that seed in the jury's mind. And that's what the defense team has got to do. That's what their job is. Their job is to create a doubt. And that jury, a little bit of doubt here, a little bit of doubt there, and you could wind up with, God forbid in this case, an exoneration, if he's acquitted of all charges. So again, I think that everybody's dotting their I's, crossing their T's in this case. And I'm pretty certain that the evidence that's going to be put forward is going to be very powerful, just based on the evidence that we know about. There's the other stuff that we don't know as well.
Folks, this is Police Off the Cuff, real crime stories. If you like real crime, true crime from a police perspective, you're in the right place. And if you're not subscribed to us, go on our YouTube. Hit that subscribe button. It's free to subscribe. Hit the subscribe button. Give us a thumbs up and ring that bell. If you want to support us financially, we have a Patreon with 3 different levels. And we also have a YouTube channel membership with, count them, 5 different levels. You see the folks in the green font? They're part of our subscribers, our friends, our family that support the Police Off the Cuff podcast, who we've been at this like in different forms for over 4 years now. And we're growing, and with your help, we're going to grow even faster. I want to just go back a little bit to Dan Abrams. I'm going to play a little bit more of him, and then we're going to get into what is potentially some of the evidence in this case.
Attorney and host of the Law and Crime Network and News Nation legal contributor, has been following the case closely. And of course, Brian Enton, our senior national correspondent, who has been all over this story from the start. Brian, let me start with you. Were people surprised about this development? Family members, others who are close to the case?
I don't think it was a big surprise, Dan. There was this thought for a while that this may have been happening behind the scenes and just no one knew about it. Word started to trickle out last night. They actually signed the true bill yesterday, the grand jury. So it started to get around last night. Now, no preliminary hearing. I think that's a bit of a relief for some of the family members. I think some of them also feel good knowing that the evidence.
I think it might be a relief, but for the press, they were looking forward to the circus that this was going to bring. And I even heard them say, "Oh, we were getting ready to our tents," and I was like, "Oh my God, this was going to be a circus." Ashley Banfield had spoke about that. We were getting ready to, basically in mass move into this area.
Evidence did stand up, and that the grand jury thought there was enough for things to move forward.
Now, Jesse, Kohberger had waived his right to a speedy trial.
Yep.
Previously.
Yep.
That means that there's time.
Yep.
They could take their time. And instead of taking their time to prepare for the preliminary hearing, prosecutors went and got a grand jury. Do you think if he hadn't waived that it could have forced prosecutors to have a preliminary hearing earlier?
Possibly, because what does this do now, right? We don't know exactly what was presented to the grand jury. We don't know how much evidence they actually have. And of course, if this went to a preliminary hearing, Kohberger's defense teams would have an opportunity to cross-examine the prosecution's witnesses. They could present their own witnesses, and any deficits you see in the prosecution's case would be exposed and be made public for all to see. This grand jury, I think it was a really smart move by prosecutors because now.
Something, guys, I don't think there's a single person that is a professional in the criminal justice field that doesn't think this grand jury move was a slam dunk, home run, grand slam, and they can't argue with it. Mike?
Yeah, Billy, this really short-circuited the defense's strategy. The defense was looking forward to beating up, Bethany Funk and maybe some of the detectives and the crime analysis people, that sort of thing. And now they have to cool their heels, and they don't know the strength and the weaknesses of those witnesses until they can read the grand jury minutes. And they'll be provided with the grand jury minutes in a month or two, but they won't have seen them actually testify. All they'll have is the actual typed transcript. So it really puts the defense on the defense, and the prosecution did a great thing.
There are folks that are not familiar with the criminal justice system, and they almost view this as, oh, that wasn't fair. What do you mean it wasn't fair? They're both, there's a this is a courtroom is an adversarial place, and the stakes are huge, and there is strategies, and there is the criminal procedure law, which the prosecution must follow. So as long as they follow the law and they don't do anything unethical, then this is fair game, just as the defense going after the witnesses before there was even a grand jury indictment, which is what we have now. Phil, go ahead. I can see you want to talk.
Yeah, I want to just make a comparison. If they were allowed to get the two hearings, the hearing before the trial and let's say at the trial, now they could have taken this position. Very, very soft and calm. Could you tell us what you told the police? Go very, very soft on either DM or BF in this case. Now, they get them in the trial and they could go hard on them and come out with allegations and didn't you say this and were you incorrect and inconsistencies and maybe rattle them, to maybe bring down their suspicion a little bit about the defense team. Are they going to be hard on me? It's going to make them relax a little bit at ease if they did that. So this move by impaneling the grand jury, getting him indicted, precludes all of that. Now, the only time they'll get to actually cross-examine them will be at the trial. And let's see if these witnesses are going to be able to, withstand cross-examination. Like I said before, they were traumatized once. It's going to be reliving it. It'll probably be traumatic, but if the prosecution does a good trial prep ahead of time, I think she'll do fine.
Folks, one of the things this means, and I'm going to repeat it for those that either tuned in late or folks that hadn't been listening, this Monday at 0900 hours, that's military time for you non-military people.
I like that, Billy. I like that.
Or 9 a.m. for you bank tellers. I'm just trying to be funny. I'm not being disparaging to anyone. Bryan Kohberger will be arraigned in the Latah County Court, and at that time and place, he will make a plea. He'll make a plea, guilty or not guilty. I mean, everyone would be shocked to the bone if he says, "I'm guilty," because he's also going to be coached and has been coached by his attorneys, but he's going to be coached that no, you say not guilty and you say it assertively, So, and then again, the judge will come up with a trial date, a date for the trial to start. And before the judge does that, he's going to poll the defense, he's going to poll the prosecution. What is your calendar like? And they'll agree upon a date. And that date could still be subject to change. So it's not in stone. Mike.
Yeah, we expect probably the trial at the earliest would be, after Labor Day. It could be not until next January, depending on, the feelings of both the prosecutor and defense. Now, remember, Kohberger waived his right to a speedy trial, and that gave the prosecutors, 6 months from December 30th when he was arrested, like January 2nd when he was actually brought back into Idaho from Pennsylvania, all the way till June. So that was 6 months. And so they gave that up, the speedy trial right. Probably, and that was at their request. And probably the judge would be more than willing to give the prosecutors, like say if they wanted 6 more months. That would bring us all the way to almost Christmas. So it's this is all strategy, long term. You're playing a short game, you're playing a long game, and we will see the trial Thanksgiving or Christmas. I wouldn't be surprised if it wasn't until Thanksgiving or Christmas.
Absolutely.
Just by some time, they can build up their case and they don't have to explain everything that they have. And again, it puts the defense in kind of a position where they're trying to figure out what they're going to do.
I mean, Brian, I guess what I'm trying to figure out here is, did the defense get snookered here? Or is there a sense that they shouldn't have waived their right to a speedy trial and kind of forced the prosecution's hand earlier?
I think there is a sense that the defense knew that this may have very well been happening behind the scenes. Apparently, this is a tactic that's taken quite a bit in Idaho. And I think they knew that there was a very, very strong possibility that behind the scenes, in secret, this grand jury was meeting.
What are we expecting to happen Monday?
He's going to be read the charges, which is no real surprise. It's not going to be like any big developments. This case is going to progress forward. It's a win for prosecutors, but we can't forget, it's not the major win. They still have to prove their case beyond a reasonable doubt at an eventual trial. And the defense, they're still going to exploit what we heard from a few weeks ago, where they believe one of the surviving roommates has information that's going to exonerate their client. We don't know what that information is yet. The defense will have their opportunity to fight this case, just not now.
But I think we have a pretty good idea, don't we, Brian, of what the defense believes is the potentially exonerating evidence that the other person who was in the home could provide?
Yeah, I think they're questioning exactly what she saw. I'm starting to see an indication that they're going to really go after the DNA evidence, whether it was actually legit, what was found on the knife sheath, why it may have had to be sent to a lab out of state.
My guess is that based on the warrants, et cetera, the fact that, she saw certain things, what she heard and didn't hear, et cetera, in the house, they're going to say, aha, see, this helps our client. But I don't think any of it is going to get to the point of someone saying, well, this completely exonerates my client. Thank you for watching.
Interesting, but nothing we haven't said already. One of the things that I want to play devil's advocate, Dylan Mortensen saw a man walk by with bushy eyebrows, fitting the physical description of Bryan Kohberger, wearing what was described as a COVID mask. Has anyone thought of the possibility if, when Dylan Mortensen gets put on the stand, if she is asked by the prosecution, can you identify the person who you saw that morning of November 13th walking by you with bushy eyebrows and a COVID mask? Can you identify that person? Has that ever been thought? And what if she says, yes, it's the defendant? How strong would that be? Or would she get ripped to shreds by the defense?
Mike, that sounds like a question.
Okay. If I'm the prosecutor, I'm going to play conservative because you have a lot of scientific evidence. You've got a lot of electronic evidence. Let that speak for itself. I think when you put DM on the stand and and BF on the stand. You just ask him a few questions. I would not want to go there because I would not want to put her in that position where if she makes a timid yes, it would leave a huge opening for the defense to attack her. And I wouldn't want to put her in that position. I would have,
Mike, but obviously that question would be asked of her in her pre-testimony interviews by the district attorney.
Right.
So obviously, if she was going to say, "Oh no, I don't know," they wouldn't ask it. But if she says, "I can ID him," would you lose that as a prosecutor if she says, "I can identify him"?
No, I'm sorry. Yeah, if she could positively identify him, I would say you gotta ask the question. However, the defense is still gonna go after her by saying, "You're seeing him, the defendant, sitting here behind the defense table. You've seen his likeness all over the place."
I was just going to say that.
Exactly. This is what the defense always does when they see a famous case where there's a wanted poster. You identified the person of the wanted poster. She's identifying the person who's on the news media. And I would say, if I'm the defense attorney, I'd be like, Your Honor, let's see if she could actually do a positive ID, and we'll do a walkthrough in a semi-dark room where there's 5 other fillers walking by with masks on, that sort of thing. And it's one of those things where no matter what it's going to be, she's going to be attacked by the defense. No matter what she says, she might, it's a tough call. Bill Thompson kind of like a tough call.
Here's what I think. If I'm the defense, I'm going to ask her, "You saw a figure on the night of the night in question?" "Yes, I did." "That person was wearing a mask?" "Yes, they were." "Could you identify that person?" Now, based on what she says right there, if she says, "No, I couldn't," you're gonna continue on with that. Say, obviously, the person that you saw had a mask on. You couldn't ID it. You can't say, and point to the client and say, "You can't identify Bryan Kohberger as the person that you saw that night." Now, if she says, "Yes, I can identify him," and you're going to say, the defense attorney is going to say, "Well, are you saying that my client is the guy? How could you possibly have? You described the person that it was dark. It was 4 o'clock in the morning. You were sleepy. You were intoxicated, whatever. The person had a mask on." So it's going to work both ways for the defense. Whatever she says about that, they'll be able to attack it both ways.
Absolutely.
Absolutely they can attack it, but it's a dangerous thought. It's a dangerous witness. And obviously, Mike, the number one rule of a defense attorney is never ask a question that you don't know the answer to. So they gotta tread very carefully on that thin ice, because if they ask her, "Is this the?" and she says, "That's the guy," the case is, I'm not going to say it's over, but it's a strong piece of testimony.
Sure. Yeah. And if she says, "Yes, that's the guy," but she doesn't sound convincing, because remember what we saw in the affidavit from the original, probable cause arrest affidavit. It was very, very dark. It was murky. There was some ambient lighting. She saw eyebrows, and she described the person as being slim, 6 feet tall. If she does, and if she could be sincere, if she says, "Yes, that's the guy. I know it's the guy. I'm not just identifying him because I've seen his picture 1,000 times all over the news. That's him." If the jury doesn't buy it, then she loses credibility. So it's a tough, like Phil said.
Well, Mike, let's reword it. It looks like the guy.
Right? Does it look like
that I saw? Because then you don't lock yourself into a corner. It looks like the guy that walked past me.
Right.
He's got the same bushy eyebrows. He's got the same physical description. His face is the same shape. He did have a COVID mask on, but it looks like the same guy. I can't 100%.
Right.
That's still pretty strong testimony.
It's still good. You don't have to say 100%.
I think Mike is onto something, because her response, that's the key. Her response to the question is going to be what the jury's going to be hanging on. And if she says, "That's him, that's the guy that murdered my friend," something of that nature, or "I know that's him, I recognize those eyes," if she comes off powerful with, "Yes, that's him," I think the jury's going to believe her, and that's going to be super powerful. That's putting him inside the house at the time of the murders. I don't think there's anything more powerful than that. Probably one of the strongest pieces of evidence if it turns out that way.
You know, guys, when we look toward the evidence now, the prosecution handed over 20,000 pages of evidence to the defense. In addition, 9,200 tips were called in during this case, during the 6 weeks of this case. And we all know, having worked major cases, when they open a tips line, probably, maybe 5 tips out of 9,000 were of any use. But you still have to investigate every single tip that comes in, because the defense probably right now, they probably have a couple of attorneys just going through all those tips and say, they didn't go out on this one. And that makes the police look bad. Oh, what, this tip wasn't good enough for you guys to investigate? Again, creating doubt. The digital evidence, very powerful. We saw the digital evidence got Alec Murdaugh convicted with that video that his son took. So in this case too, the 12 previous times he was in the vicinity of that house before the morning of the murders on November 13th. He had gone to that house, and brilliant work by the digital detectives that do that. I mean, just think of, we're going to go back 2 months, 3 months. And I think, Phil, you have some expertise in this. I certainly don't. They go back 2 or 3 months and they find out he has been to the vicinity of that house 12 previous times. Circumstantial? You bet. But strong circumstantial? You bet.
100%, Billy. And the cell phone evidence that we're talking about, the technical evidence, the cell phone records are kept for 365 days, 1 year. So in this case, it was easy to get those records to see where his phone was traveling at specific dates and times. And again, as we know, he visited the location at least 11 times prior to the night of the homicide. He came back hours after, before the police were even called at 9 o'clock in the morning. All of those things, the phone being off before he goes to location, then turn it back on about 20 minutes after he leaves the locations. Again, are going to give a Gearyism, confidence, consciousness of guilt. So again, all of those things, and we talk about it all the time, all the little bits and pieces of circumstantial evidence. And the good thing that I like about the technical evidence, whether it be cell phone, video, it's irrefutable. You know what I mean? It's so exact. If a vehicle goes by on a video, there's a vehicle in a video. Whether or not you're going to believe it's that vehicle is one thing, but you have something very solid. There's a video of a car in the area. Now you have several videos and of the same car. And we had that FBI expert that was able to determine from that flash on that video camera in the gas station that it was a 2012 to 14 or 15 Hyundai. So again, whatever it was, technical, those are irrefutable things. Video cameras, plate readers, the cell phone evidence, all very, very strong circumstantial evidence.
Someone just reminded me in the chat that yes, and how about video? So you marry the digital evidence with video, and what's your excuse?
Cameras show him leaving the neighborhood and exiting on Walenta Drive in this direction. It's uncertain which way he went from this point here, but we know that he is seen here at this location at 3:45 a.m., caught on a gas station security camera. Wondering if this could truly be a 2015 Elantra, I downloaded a known image of one with a similar angle of view. I then entered that into a 3D modeling software and added some lighting and then tilted the camera to get a similar angle. I then animated the image to be traveling at 40 miles per hour, giving motion blur, which ended with this result. Though not scientific, we can see very close similarities that this is a 2015 Elantra. Back to the map. We see the suspect re-enters the neighborhood at 4:04 a.m. He drives up to the house and slows down. Looking at the windows, he sees the lights are now off. Continuing to the back, he checks to see if those lights are off. They are. He's excited. He knows everyone is finally in bed, but he wants to check the front one last time. As he drives down, he's filled with adrenaline, seeing the lights are all off. His brain short circuits for a second as he clumsily tries to turn around in front of the house. It fails, but he regains composure and drives on. He's caught on camera making a 3-point turn at the end of the street to return back to the residence.
When you marry this video evidence, again, this is a recreation on 3D, but there is video. There's real video of this, of what she's explaining here happening. So we use the term circumstantial evidence, that from which inferences are drawn. Powerful inferences, seeing his car parked in the backyard of the house where 4 people were slaughtered. Circumstantial?
Very powerful.
Yeah.
Circumstantial,
Very powerful,
yes,
though.
but very, very powerful circumstantial evidence. And as I said, marry that with the digital evidence. Put it next to the digital evidence, and what was he doing there? And we don't even know about a lot of the physical evidence, blood evidence, DNA evidence. There's probably, we discussed this numerous times before, there's a 99% chance that he cut himself and left his blood in that crime scene. They're not offering that to the defense at this juncture. Trust me. They will get that. And when they hear that, I don't know what their explanation is going to be. If his blood is in that crime scene, I don't know how you fight this case. Yeah, I don't know how you do that. But there's a way, because they're defense attorneys. But that would be, and again, we don't know, we don't know of all the evidence they have.
He does his final drive to the back of the house. In the beginning, most of us believed the 2 surviving roommates, Bethany and Dylan, were sleeping on the first floor. Since then, we've learned Dylan was sleeping here on the 2nd floor, along with Xana and Ethan located here. Kaylee and Madison were located here on the 3rd floor. The dog was located on the 3rd floor and the room by itself. Let's move around and see through the walls into the kitchen, to the back slider, and take a look at the time frames. At 4:04 a.m., the suspect can be seen trying to park his car. At 4:09, approximately 5 minutes later, he enters the house through the back slider. At 4:18, he leaves the house after committing the crimes. At 4:20, he's caught on camera driving away at a high rate of speed. All of this only took 9 minutes. Let's watch what that looks like. The suspect enters through the back sliding door. He pauses at the stairs to look around to make sure no one's up. He then turns and goes upstairs. The first bedroom he stops at and opens the door, he sees no one there. He continues to the next bedroom. Here we know what happens. Downstairs, Dylan is sleeping. The noise from upstairs wakes her up. She thinks it's Kaylee playing with her dog. She gets up and goes to the door and looks out. She sees nothing there. The suspect then continues down the stairs about 3 minutes later. He then heads to Xana's room. Outside, there's a security camera picking up some whimpering, cries, and a thud at 4:17. We've learned that Xana was found on the floor, which might explain the thud. Dylan again hears something and looks outside her door. She sees the suspect. He walks right past her and leaves.
Wow. That's all I have to say with that evidence there is wow. And I don't see the prosecution using this. They'll have their own person put the video and the time frame and the digital evidence, and they'll marry that and they'll show this to the jury, not this one. They'll create their own video of what they have and marry it again with the digital evidence, the cell phone, the cell site information. Circumstantial? You bet.
Billy,
Powerful? You bet.
I was privy to a trial in 2019 where there was numerous video cameras capturing a perpetrator before, during, and after a homicide. And what they did was they created almost like a motion picture. It was about a 40-minute long video where they had videos, then they showed the cell phone where it located the person. Then they went back to videos. So they took a whole bunch of videos and they compiled it together and they made what I thought was the equivalent of a motion picture. It was super powerful when it was played in court, and the perpetrator was found guilty within a few hours of the end of the trial during deliberation. So again, something like that is very, very powerful. It was put together by the Brooklyn DA's office. Like I said, about a 40-minute long video, all different clips of video. The video would stop. The district attorney would point out what they believed was in that video. It was all very, very believable. It wasn't unreasonable, and super powerful, led to the conviction.
Look, there's no doubt in my mind this is not going to be an easy case for either side, but even for the prosecution. The only thing is if the evidence, if they have blood evidence, his blood in that crime scene, I find it nearly impossible for the defense to explain that. Mike, what are your thoughts?
Yeah, I mean, they can try, but just because you can come up with some sort of wild excuse doesn't mean that you're entitled to have a jury believe you. If there's if his blood is at the crime scene, if the victim's blood is in his Hyundai, if he's got as I heard reported, they found some identification cards, like ID cards. If one of those four from Madison Mogan or Knodel or Chapin, their ID card is in his possession in Pennsylvania, you can come up with some sort of wild explanation, but you're not entitled as a defense attorney to have anybody believe you. So that would be what you would call like pretty much a slam dunk. Just like the DNA evidence, it's all circumstantial, but it's very, very powerful evidence.
Absolutely. Phil.
Joe Murray, attorney at law. So listen, guys, if you found yourself in a jam and you're in the New York area and you need some legal counsel or advice, there's none better than Joe Murray. Joe Murray is a fantastic criminal defense attorney. He's also a retired 15-year member of the NYPD, and he's known for his boxing skills. So he may just be able to deliver that knockout punch on your case. If you need to get a hold of Joe, you can reach him at jmurray-law.com. That's his website. You can reach him on his telephone at 646-838-1702, or you can email Joe at joe@jmurray-law.com.
Folks, I wanted to just touch upon the fact that we saw a lot during this investigation, especially before they had a perpetrator. And I called them talking heads. There were talking heads on every channel, some very knowledgeable. And I'm talking specifically about the behavioral analysts. And many of them were from the FBI. Many of them made predictions who this person was going to be. We made predictions of who this person was going to be prior to the arrest. And we were pretty close. I made a prediction. I was right on, except I thought the person was going to be a townie person. That was going to be someone that lived in the Moscow-Idaho area. And it turned out, again, not to be.
He did live in the area, Bill, technically.
He did. He lived in.
He wasn't a native of that area, but he did live in the area. So
right, he lived in
I was
Pullman.
on the same page with you.
Right, he lived in Pullman, Washington. But one of the reasons I'm bringing this up is that will behavioral analysis come into play during this case? Will the prosecution, because it became such a big thing, and I know this is a segue. This is sort of unfair because I'm plugging our show Monday night. But Monday night, we have Dr. Joni Johnston, actually, a forensic psychologist who is an expert in the interviewing and profiling and an expert on serial killers. Will they bring someone like that into this trial to explain the behavior of this person? Mike?
I think the prosecutor I would, if I was the prosecutor, I want to play a little bit conservative because I have a ton of, I believe I have a ton of DNA evidence, electronic evidence. I don't want to give the defense attorney on cross-examination the ability to go after my psychologist or my psychiatrist. But I could see it definitely coming in the defense's case. If it's a death penalty case, Bryan Kohberger, I don't think has anything to lose by trying to take the stand in his own defense and then having a defense attorney present some sort of specialist in in behavioral analysis when it comes to people who may have some mental health issues. There's no insanity defense in Idaho, but you'd be able to perhaps present some sort of mitigating the circumstances to the jury. But if I'm the prosecutor, I want to stick with the technical stuff that I've got mastery of, and I don't want to go into the speculative, psychological stuff that could lead the jury to start analyzing theories of mental health issues when I really, as a prosecutor, want them to concentrate solely on the scientific stuff that I have laid before them.
Billy, I want to make a comment about the profile. If you bring a profiler into this case and the profile is not 100% dead on, that's going to be like a home run for the defense attorney to say, well, you said that you believe that the person was going to be living in the area and my client lived in Pennsylvania. Blah, blah, blah. So again, it'll be creating doubt. I think it's kind of, it's still such a new technology that we use, profiling and stuff. I don't know if it's ready to be put out there at trials and stuff like that. I mean, sometimes they could be dead on, but most of the time it's very general. And I think in a courtroom that could be used for the defense.
No, I feel that the prosecution won't bring it up, but the defense may bring it up. So the prosecution may have to attack the defense's theory.
Right.
They had Steve Gonsalves on last night. Hang on one second. I want to play a little of this.
First and foremost, can I just check in with you and ask how you're holding up?
There's been progress, and that always helps. I feel like we have a mission, we have a job to do, we have things that have to happen. And when I see those things happening, that helps me understand that we're going in the right direction. And that's always better than just sitting and waiting for who knows what's going to happen.
So when the official news dropped that the grand jury had convened, the process had completed, the indictment was coming down, what was your reaction?
They had let us know beforehand that this process was in action and it was going to possibly happen. They kind of put it in a vague circumstance saying it could be this case, but we knew. I have a legal counsel. I talked to my legal counsel. He said, yes, it's definitely this case. So we knew that this was a possibility. So we just sat back, hoped that everybody was going to remain quiet and it wouldn't leak, because the last thing we wanted was any of the families to be accused of that. So then we kept our mouth shut and we just waited for it to happen. And then they told us, yeah, it's over. It's done.
Well, we had been making big plans, as a network, decamping to Idaho for the June 26th hearing. It was my understanding there was going to be a solid 3 to 5 days, like a mini trial, and we would have learned a lot of information. I wanted to get your take, however, on the fact that we will not get that opportunity to learn some of these mysterious holes in this case. Is it troublesome to you? Is it bothersome to you? Or are you just happy that the process is continuing?
To me, that's bothersome. That's bothersome. Mysterious holes. Where does that come from? That's TV. And something, every case has unexplained things until it goes to trial. But to call it a mysterious hole, I have a little bit of a problem with that.
Regardless of what kind of indictment we got.
No, I'm just like everyone else. I want to know exactly what's going on. I want to see all the evidence. I don't like the secretivity, like the hiding of it. But I understand why they did it. There's people who are witnesses and they need to be protected and they don't need to be dragged through every obstacle that this process goes through. And it was a wise decision to go this path. So all the information will come out, but it doesn't have to come out in multiple times in multiple ways. And we don't have to make them go through this exercise more than needed.
Thank you for watching.
So, folks, Steve Gonsalves, the dad of Kaylee Gonsalves, he has been more or less the voice of a lot of the parents. And early on in the investigation, he may have been criticized for leaking things to the press. But you know something? You can't criticize a man that had his 21-year-old daughter slaughtered. And we have to understand him. And we also have to understand that this case is about four people. And on the screen, you see it's about Ethan Chapin, Zaina Knodel, Madison Mogen, and Kaylee Gonsalves. And our system is the greatest system in the world. And I'll say it because I always get criticized when I don't say it, that Bryan Kohberger is innocent till proven guilty. That is our system. And it's an adversarial system, and the prosecution is going to try to prove that he's guilty beyond a reasonable doubt. And that's what we're working towards. And we who have been following this case, we in law enforcement, we believe that I'll say, talk for Bill Cannon, I'll talk for Phil Grimaldi, I'll talk for Michael Geary. We believe they have the right guy, and we want to see justice. And let me bring my two compadres back on. This is going to be, a complicated case, but we believe they have the right guy. And I read stuff and I watch some of the other YouTube channels, and I don't know what some of these people are talking about. Let me stop criticizing other people. But I mean, I think the case has been worked pretty damn well from the beginning. And in the beginning, we were a little critical of the Moscow police because they hadn't investigated a murder in 7 years. And we're like, but they got the help they needed. They got the Idaho State Police to come in, and they got the FBI to help them. And look at the results. They had an arrest within 6 weeks, which a lot of the broadcast media was unhappy with. 6 weeks was way too long for them. This was a cold case, and I can just say, as someone who's worked homicides in New York City and Manhattan North for almost 10 years, that 6 weeks is not unreasonable, and it's not a cold case after 6 weeks. So if I get emotional about this stuff, it's because, something, strap a gun on your right or your left hip, depending on what hand you are, and go out on patrol, and then you can be judgmental. I'll take what you say as gospel. No, well, not as gospel, but I'll take more credence to it. If you walk the walk, I'll let you talk the talk. Phil, final words.
Final words. I think that the video that you played, the animation, I think that was very powerful. It was a great adaptation of what we believe happened. And I'm just so happy to see that Mr. Gonsalves is on the same page now with the prosecutors. Everybody was very quiet about the grand jury proceeding. And again, I'm going to repeat the names: Zaina Knodel, Ethan Chapin, Madison Mogen, and Kaylee Gonsalves. Those are the victims in this case. May God bless their souls and their families. That's what this case is about. It's about the victims. Again, our system of justice says that the person has to be proven guilty. We believe, as law enforcement officers, what we know, what we see, that he's the right guy. Now they have to prove it in court, which I think is going to happen. There's a lot of evidence in this case. So let's just stand by, wait for Monday. We'll see the outcome of the hearing. And then hopefully there'll be another proceeding in June, and then the trial sometime either later this year or early next year. And we'll go from there.
Okay. Mike Geary, it's always a thrill to have you on the show because you're the man of reason. You're the calm influence among two emotional guys here. I know I get a little emotional. Phil gets emotional as part of his makeup. And you have that real cool professorial.
He's steady. He's steady.
Yeah, he's very steady. If I was on the heart monitor, I'd be like this, but Mike just goes across the screen really cool. And I think people appreciate that, Mike. And, before the show ends, I just want to thank you for coming on and for bringing what you bring to this show. Mike, your final words.
Well, we've counseled on this show to all the listeners in the beginning, before Bryan Kohberger was arrested, to have patience and to have faith that the Moscow Police Department and the FBI and the Idaho State Police did a thorough job. And the same thing applies here. Have patience. We're not going to have that late June feeding frenzy that Ashley Banfield had referred to, but I think we're better off for it. And
How
we're
did
gonna
she
meet-
refer to it? We were going to go camp. I mean,
Yeah, like camp out. Yeah, she was looking forward to it.
wow.
Billy, that upset me too when she talked about the holes in the case.
No.
There's no holes
Yeah.
in this case.
No, there's no perfect investigation, but rest assured, with all of the technical assistance that was given to the Moscow, Idaho PD, that they've done everything by the book, and the investigation led them to the person most likely responsible for these homicides.
Absolutely. Folks, I thought it was not to pat myself on the back, but I thought it was a pretty damn good show tonight. And I want to thank my two co-hosts, straight out of Brooklyn, retired NYPD Detective Phil Grimaldi, and Mike Geary. I think he's straight out of the Bronx. I think the last time I checked in, straight out of the Bronx, professor,
And very
retired,
even keeled.
and very even keeled,
Thank you.
retired NYPD sergeant and an attorney. You can't get much better than that. Folks, thank you so much for tuning in. We thank you, our fans, our subscribers, our friends. Have a great night and God bless.
Stay safe, everyone. Good night.
Good night.
One episode just ain't enough.